There's something that happened to me in federal court recently that has been eating at me ever since. And honestly, I think it exposes one of the biggest myths in the American criminal system, the myth of the presumption of innocence. Now, before I get into this, let me give my standard disclaimer. I'm a criminal defense attorney licensed in Arizona. Nothing in this video is legal advice. Every case is different. And if you're dealing with a criminal case, you need to speak directly with an attorney about your specific situation. But let me tell you what happened. I represented a client at a federal disposition hearing. My client was on supervised release, which is basically federal probation. It's not exactly the same thing legally, but it's close enough for the purposes of this conversation. While he was on supervision, he got arrested and charged in state court with a domestic violence offense. Now, here's the important part. He's not been convicted of that offense. In fact, we are actively fighting that case. And I have evidence suggesting that my client may actually have been the victim in that situation. But despite that, the mere existence of the charge triggered a petition to revoke his federal supervision. And this is where things start to get really uncomfortable. Because one of the conditions of supervised release is essentially do not commit new crimes. Okay, fair enough on paper. But in practice, what often ends up happening is that people get punished not because they were proven guilty of something, but because they were accused. And that should bother people a whole lot more than it does. Because think about the logic here. A person does not control whether they get charged with a crime. Police officers decide that. Prosecutors decide that. Sometimes people lie. Sometimes witnesses are mistaken. Sometimes relationships become toxic. Sometimes police get things wrong. And yet somehow in the supervision context, we often act as though it's the filing of the charges themselves that prove misconduct. That's a massive problem. Now, because we're still litigating the state case, my client was not in a position to admit that he committed domestic violence. And strategically, legally, ethically, that would have been a disaster. So I reached out to the probation officer and I explained the situation. And I basically said, look, if there's a technical violation here that he can truthfully admit to, maybe we can resolve this matter without forcing him to admit to conduct he disputes and that we're actively defending against, and we can avoid having to have a mini trial for you guys to prove the domestic violence. To probation's credit, they worked with us. A technical violation was indeed added. My client admitted to it, and then we moved to disposition. Now, by the time we got to that hearing, my client had already spent roughly 3 months in custody. 3 months. And I argued that was enough because the violation he admitted to was technical in nature, because he had tremendous family support, because the courtroom was packed with people who believed in him, because he had been doing well before his arrest derailed his life, because incarceration has real collateral consequences that people who have never experienced the criminal system often completely fail to appreciate. Jobs disappear, housing becomes unstable, families suffer, mental health deteriorates, people lose momentum. 3 months in custody is not some minor inconvenience. It is punishment, serious punishment. So I argued for the time served. Probation wanted 6 months total. The government agreed with probation, and the judge ultimately imposed the 6 months. But here's the part that really got my goat. It became very clear during the hearing that the domestic violence charge itself was driving the outcome, not the technical violation, not what he admitted to, the unproven allegation, the pending case, the accusation. I pointed out to the court that my client is presumed innocent. I pointed out that we are contesting the allegations. I pointed out that I have evidence supporting his position. And the response I essentially got was, well, you can appeal. Now, to you non-lawyers watching this, let me explain why the response can feel so hollow sometimes. Appeals take a very long time, a year sometimes, could be longer in some situations. And if somebody is serving a 6-month sentence, by the time the appeal gets resolved, that sentence is already over. The damage is already done. The lost time is already gone. And appellate courts generally give enormous deference to trial judges, especially when the sentence imposed falls within an otherwise permissible range. So when people casually say, oh, just appeal, they often don't understand the reality of what that means. And this experience has really forced me to confront something that I think that defense attorneys in general see all the time, but that the public often does not. The presumption of innocence is far weaker in practice than people think it is. Now, don't get me wrong. It absolutely matters legally. It matters at trial. It matters constitutionally. It matters procedurally. But culturally, institutionally, emotionally, people often treat accusations as proof. And once that happens, it changes everything. It changes how employers react. It changes how families react. It changes how courts sometimes react. It changes how probation reacts, and it changes how prosecutors react. And if we're not careful, we end up creating a system where people are effectively punished before their guilt is ever established. And that should concern everyone, not just people accused of crimes, everyone. Because rights do not mean very much if they disappear the moment they become inconvenient. And one of the reasons I make videos like this is because I want people to understand that the criminal system is far more complicated, far messier, and far more human than television and political slogans make it seem. Sometimes judges get things wrong. Often prosecutors get things wrong. Probationers get things wrong too. And sometimes defense attorneys lose arguments that they believe deeply in. That's what happened to me here. And yeah, I am angry about it because I genuinely believe my client was punished, at least in part, for conduct that has not yet been proven. And I think that should disturb people. Because if the presumption of innocence only exists on paper, then we need to start asking ourselves some very uncomfortable questions about what kind of system and what kind of society we actually have. So I want to hear from you. Do you think people are truly presumed innocent in this country? Or do you think that accusations alone are often enough to change how the system treats someone? Let me know in the comments. I do read them. And if you think conversations like this matter, subscribe to the channel. Because one of the goals here is not just to explain the law, but to pull back the curtain of how the criminal system actually works in real life. I'm Chorny. Your rights matter. Protect them. Stay safe. And I'll see you in the next video.